I'm Melvin L. Raymond, attorney and counselor at law. Welcome to Raymond Law Live. Before we start with today's topic, I want to invite all of you to use our resource for you to become better acquainted with the law and your rights. We call it What's Your Need? This allows you to tell us what topics you want us to cover in future broadcasts. Simply email us or call us at the office with your topic of choice. Our email address is mraymondattorney, that's MRAYMONDATTORNEY at sbcglobal.net. Our telephone number is area code 314-534-2800. Our topic today is sexual harassment in the workplace. If you are the victim of sexual harassment in the workplace, what can you do about it? Well, there's good news. There are legal protections against sexual harassment in the workplace, and we're going to be answering your questions about and dealing with the subject of what you can do, what action you can take about sexual harassment. Now, the law offers protection both at the state of Missouri level as well as the federal level. Missouri has the Missouri Human Rights Act at the state level, and at the federal level, there is Title VII of the Civil Rights Act of 1964. Now, what is unlawful harassment, sexual harassment in the workplace? That is the first question. Sexual harassment in the workplace is a form of sex discrimination or gender discrimination. The Missouri law, that's the Missouri Human Rights Act, defines discrimination as any unfair treatment based on membership in a protected class. So it's not merely unfair treatment, but the unfair treatment has to be based on a protected class or characteristic. This is also true under the federal equivalents, that is, various laws against discrimination, including the Title VII of the Civil Rights Act of 1964. Now, what are those protected classes or characteristics? Sex, of course, or gender is one such protected class or classification, and that's what we'll be dealing with primarily today. There are others. What are the others? Because there's a whole range of laws against discrimination based on not only sex or gender, but also race, color, religion, national origin, ancestry, age, and disability. We'll be dealing with some of those other aspects of discrimination, unlawful discrimination, in future broadcasts. Now, so you have the categories. So we're dealing with discrimination based on sex or gender. That is what the category that sexual harassment falls under. Now, what are the kinds of sexual harassment for which you can get a legal protection? There are two kinds of sexual harassment. The first is so-called hostile work environment sexual harassment. And the second is the so-called quid pro quo or this for that discrimination. Let's deal first with the hostile environment type of sexual harassment. Now that occurs when, one, there is unwelcome sexual conduct, and this is, again, all of this applies to conduct that occurs in the workplace. Conduct in the workplace. So it has to be unwelcome conduct, and it has to be based on gender, or it could be harassment based on one of the other protected classes such as race, color, religion, and so on. Of course, today we're talking about sex or gender discrimination, and the unwelcome conduct has to be severe enough to alter the terms of the person's or the victim's employment, and the employer has to be aware of the unwelcome conduct and fail to take immediate, effective, corrective action. So that is what sex discrimination or sexual harassment based on hostile environment. Those are the elements there. The other kind of sexual harassment occurs when there is a so-called quid pro quo, or this for that. Now, that occurs when there is conduct where submission to sexual advances of a superior or a supervisor was a term or condition of employment. And number two, the non-submission substantially affected employment chances. And the third thing is workers of the opposite sex were not affected in the same way by the unwelcome sexual advances or the unwelcome sexual conduct. Now, who is liable for sexual harassment in the workplace? If the alleged harassers are co-workers, then the victim must show that the employer knew or should have known of the harassment and failed to take prompt, effective, corrective, or remedial action. And also, you need to have other factors to establish a claim of sexual harassment with coworkers is severity, frequency, whether or not the conduct was physically threatening or humiliating, and so on, and not just a mere offensive utterance. And another factor to consider is whether or not the conduct unreasonably interferes with the employee's work performance. Now, as far as quid pro quo or this for that, that involves being subjected to unwelcome harassment in the form of sexual advances or requests for sexual favors. Again, the harassment has to be based on sex. That is, because of your gender either being male or female, and submission to the unwelcome advances or conduct was an express or implied condition for receiving job benefits, or refusal to submit resulting in intangible job benefits. That is, by refusing to submit to the unwelcome advances, it results in a job detriment with respect to a benefit or another term or condition of employment. Now, in both the hostile work environment and the quid pro quo cases, the behavior has to be unwelcome. That is a critical element there. It has to be unwelcome. So obviously, for instance, a consensual office romance or romantic relationship is not obviously unwelcome. It's consensual between both parties, and this, for instance, cannot constitute unlawful sexual harassment. And it also must be based on gender or sex or some other protected categories such as race, religion, color, etc. And what do we mean by the harassment must be based on sex or gender? We mean that, or it's a situation where one sex is exposed, either male or female, is exposed to disadvantageous terms and conditions of employment to which members of the other sex are not exposed. So, if, for instance, an example would be if an alleged harasser exposes both men and women to the same behavior. If that's the case, both men and women are subjected to the same behavior by the alleged harasser, then that means that it's not based on sex because both men and women are being treated equally. So that gives you a sense of what based on harassment based on sex, what that means. Now, as far as who is protected by sexual harassment, Well, both males and females are protected from sexual harassment by Title VII, the federal law, and also by the law in the state of Missouri. Again, workplace sexual harassment against, the idea here is that workplace sexual harassment against women because they are women and men because they are men. So that's the heart of what it means as far as sexual harassment. Also, same-sex harassment claims can also be filed, so that is protected. So a person of the same sex can be harassed by another person of the same sex, and it doesn't necessarily have to be, the harasser doesn't necessarily have to be gay or homosexual in order for a claim for sexual harassment to be filed. It's just got to be based on sex or gender. Sexual harassment can take various forms. It could vary from rude talk, sexual or personal remarks, name calling, requests for dates and sexual favors, lewd gestures. So those are some of the kinds of forms that various acts of sexual harassment, the form that it can take. A second question which arises is for victims of sexual harassment is which employers are covered by the Missouri law. Every Missouri employer having six or more employees, and that includes the state of Missouri and any subdivisions of the state. So you got to have 6 or more employees in order for an employer to be covered by the Missouri Human Rights Act. Now for the federal law, the number is 15 or more employees, and that includes federal, state, and local governments. So the law, both the state law and at the federal level, it covers all state and local agencies and state and federal agencies as well. And so it doesn't cover, however, the smallest employers. You got to have 6 or more to be covered by the state laws I just mentioned. The other thing, as far as who is covered, as far as employees can file claims for sexual harassment. You have to be an employee, and there must be obviously an employee-employer relationship. Now, just because you do some work for someone doesn't necessarily mean that you are an employee. Independent contractors, for instance, are not considered employees, or freelancers who work on a contract are not considered employees, and they would not be covered. So you have to have an employer-employee relationship. When is an employer liable for sexual harassment? We mentioned sexual harassment by co-employees. So when is the employer liable? An employer is automatically strictly liable for a supervisor's sexual harassment if the harassment results in a tangible employment action occurring. So you have to have the act of a supervisor of an employer, and you have to have a tangible employment action. Even if the employer is unaware of the supervisor's behavior, the employer is still strictly liable. Now, what is a tangible employment action that you need if there is a sexual harassment by a supervisor? Well, it has to be something that can significantly affect your employment. That would be hiring or firing or a significant change in your responsibilities. It's those kind of actions resulting from sexual harassment that makes it unlawful. Employers have been also held liable for co-workers harassment. That is, harassment by co-workers. That's not automatic liability, but if the employer knew or had reason to know or should have known of the harassment, and 2, the employer failed to take prompt and appropriate corrective action that is reasonably calculated to stop the harassment, in those instances, the employer is liable for co-worker harassment. That is, harassment by a co-worker. We will take questions and comments. You can post them, and we'll get to those as soon as we can. An employer also may be held liable for harassment when the harasser is sufficiently high in the management. For instance, if the harasser or alleged harasser is the company's president or the company's owner, then he is considered or treated as the alter ego or proxy for the employer. So if, again, it's the owner or the president or the CEO, a pretty high-placed person in the company, then in those cases, the harassment is automatically imputed to the employer. That is, if it happens, if the harasser is the president or CEO or a high official, then they are liable automatically, regardless of whether or not, obviously the employer knows, but regardless of whether or not the harassment resulted in a tangible employment action such as hiring, firing, a significant change in responsibilities, and so forth. So it's strict liability in the case not only of supervisors, but also for highly placed individuals in the management, such as a president or an owner. Now, what kind of damages can one recover in cases of sexual harassment if an employer is found liable for sexual harassment? Well, punitive damages can be entered against the employer if there's evidence that the conduct was malicious, or the employer had reckless indifference to the protected rights of the aggrieved individual. So again, if there is reckless disregard or malice, then the employer, malice means that the employer was acting and committing acts of sexual harassment when he knew or had reason to know that he was likely violating the law by committing acts of sexual harassment. Also, you can recover attorney's fees if you prevail on a claim of sexual harassment. You have to prevail on the claim in order to obtain attorney fees. And there are other kinds of damages depending on how the victim is affected by the acts of sexual harassment committed against the victim and the nature of the acts. Obviously, some acts are worse than others, such as physical threats, sexual assaults, and so on. If that is the form of the sexual harassment, then there could be additional damages that could be recovered. So, what are the procedures if you are the victim of sexual harassment? First, you have to file a charge of discrimination, and you can do that with either the Missouri Commission on Human Rights. The Missouri Commission on Human Rights is the agency at the state level that handles in the first step of the process of taking action, that is, taking action for sexual harassment. The Missouri Commission on Human Rights is located here in St. Louis. They're downtown in the Wainwright building. You can also go to the federal agency that handles claims of discrimination based on sex, i.e. sexual harassment, and also other claims of discrimination based on the other protected categories: race, color, religion, ancestry, age, disability, and so forth. The EEOC, we call it Equal Employment Opportunity Commission. Same procedure. You have to go into them, or you can do it by mail. I suggest that you go in to file a charge of discrimination based on sexual harassment if you are the victim of sexual harassment. So they will interview the victim when you go before to the agency to file a charge of discrimination, and they will prepare a written charge of discrimination, and then they'll send that to the employer. I will take any questions or comments you have on the topic. Just post them and we will get to those. So once you file a charge of discrimination, then either the Missouri Commission on Human Rights at the state level or the EEOC at the federal level, then they will do an investigation and it goes on from there. So that is what you should do if you are the victim of discrimination. Go to the Missouri Commission on Human Rights or the EEOC. Both are located, if you're in the city of St. Louis or the greater St. Louis metropolitan area, they are both located downtown. The Missouri Commission is in the Wainwright State Office Building downtown. The EEOC, or the Equal Employment Opportunity Commission, is at the Robert A. Young Federal Building downtown. So they both have jurisdiction over claims of sexual harassment. We have a question here. Is there a period of a statute of limitations or a time period for reporting sexual harassment? The answer to that question is yes. If you're going to file at the state level, you have to file the claim within 180 days of the date that the alleged act of sexual harassment occurs, unless it is a continuing violation. If it's repeated and continuing, and there have to be special circumstances. There are instances where it could be continuing, but normally you have 180 days or 6 months under the state law of Missouri, and it's a longer period for filing claims of sexual harassment or other claims of discrimination. It's 300 days from the date of the alleged occurrence of the act of sexual harassment. That is about 10 months. That's for under the federal law. So if you miss the 180 days under the state law, then you can go and file a claim under the federal law. It's about 300 days. So there are different time periods there. I have another question. Can the employer be liable for sexual harassment acted out? Well, let's see. Let me look at this question. Oh, yeah. I think the question relates to whether or not the employer can be liable for sexual harassment if it's harassment committed by one employee against another employee. As I mentioned during the presentation, yes, there is liability if a coworker commits acts of sexual harassment against another coworker. If that happens, then you should report the harassment to management. It could be whoever the victim reports to, or you can go higher up to a higher level supervisor or manager. It has to be reported because the employer is not liable for sexual harassment in the workplace committed by one employee against another unless the employer knows about it. That is, the employer has actual knowledge, or the employer has what we call constructive knowledge. That is, they should have known. The circumstances indicate that the employer should have known, i.e. it's common knowledge that this kind of thing is going on, or the employer turns his head, he's aware of it, but turns his head, then in that instance, the employer should have known about the conduct. So yes, sexual harassment by one employee against another on the job is, the employer is liable for that. Also, there are instances where the employer is, if the harassment, and this does happen, is committed, for instance, by a customer of the employer, then the employer, again, could be held liable if the employer knows about it that is, has actual knowledge or has reason to know. And there are many cases where the employer knowingly allows a customer to commit acts of sexual harassment against an employee. The employer could be liable, so the employer has to take quick and effective action to stop the harassment. If they don't, then they could be liable. So hopefully this will make you better informed about your rights as an employee if you are the victim of sexual harassment. And if you need to contact us about that issue or for personal representation, then by all means contact our office. The phone number is area code 314-534-2800, or you can email us at mraymondattorney@sbcglobal.net. You can also reach us on Facebook.com/Raymond Law Live, or Twitter @Raymond Law Live, or RaymondLawLive.com. That's our website. I would like to thank all of you who watch this broadcast live for tuning in, and also those of you who will be watching the broadcast later. We appreciate your time and your interaction. I think I have another time for another question. Can you file a harassment charge against the same person more than once? The answer is yes, unless the sexual harassment is just a continuing kind of thing where it's just frequent and it's ongoing. If it's frequent and ongoing, then it could be such that it could be considered as just one incident. Then it is all considered one thing. You still can file a claim, but if, let's say, it occurs once and it affects your employment, a term or condition, or there's a tangible action taken against you, and then it occurs 6 months later, or there's a time gap there, and it's such that it doesn't appear to be continuing, then yes, you can. If you're a victim of sexual harassment more than once, then yes, you can file a separate claim whenever that conduct occurs, assuming that it's not part of a continuing kind of thing. So again, thanks everyone for listening, and those who are watching live and those who will watch later. Appreciate your time and interaction. So, when you fight, remember, know your rights.